I would like to say I'm here on special appearance. No, I think I have some rights here. That I'm a living soul. I am not the straw man of the all caps. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am.
What statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you? Excuse me. I probably have more degrees.
Pause here. The courtroom has just been formally opened and names are on the record. That matters. When a judge introduces the case and officials identify themselves, everything that follows is anchored to established procedure, service, filings, dates. The defendant's special appearance line signals she's trying to frame this as purely common law, but the judge and counsel operate inside statutory procedure. That mismatch is the root of the clash. Also note the judge's patience. In real courtrooms, a judge will allow some explanation but will quickly move to ensure the defendant understands charges and penalties. Watch how counsel's face and the clerk's formal steps set the stakes. This isn't a debate stage, it's a legal process with real consequences.
Thank you, sir. If you did send out. Such an interesting out.
All right, you're in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as arraignment attorney on behalf of Beth Bridgman.
Also, I will represent myself.
Yes,
okay.
We'll get to that.
I would like to say I'm here on special appearance.
Okay.
No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my.
Here's the core. The judge reads two allegations: unauthorized practice of law and preventing a defendant from meeting counsel. Those aren't minor administrative notes. They strike at the heart of court integrity. Preventing a defendant from meeting counsel can lead to serious due process scrutiny. Unauthorized practice of law is a statutory violation. The judge is setting the procedural framework. There will be a hearing, evidence must meet the criminal standard, and the defendant has rights counsel, appointed counsel, if indigent, cross-examination. The defendant's instinct to treat court papers like props is dangerous. If you're representing yourself, prepare to meet the burden of law, not YouTube rhetoric.
Thank you.
Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull a chair up, so thank you.
Well, if you want to sit there, I have no problem. Okay. All right.
Thank you.
Okay. All right. Well, Ms. Bridgman, you're here for an arraignment on two allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore, I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So,
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the two contempt citations pending against you. You have the right to have a hearing on both of those allegations, where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you.
Quick legal note: the judge just outlined the rights counsel, appointed counsel if you qualify, and the criminal standard burden. That criminal standard line, beyond a reasonable doubt, is huge. Contempt here isn't a civil slap on the wrist. This is criminal contempt exposure. If you represent yourself, you waive the benefit of an attorney's training in parsing statutory definitions and case law that define unauthorized practice. This part is a reality check. Theatrics don't replace legal argument. If you care about outcomes, you prep evidence, get witness statements, and know the case law before you speak in front of the judge.
You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
what is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the contempt. Do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call into the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me.
Notice how the defendant keeps arguing jurisdiction and bond status. That's a red flag. Courts don't generally accept unilateral declarations about not being on bond. To void an order, the court's authority flows from its docket and prior orders. If the defendant believes procedural errors occurred, for example, improper service, that's a defense to raise at the hearing with evidence. But saying, I wasn't under bond on the bench without affidavits or documents won't resolve the issue in real time. The judge is giving a chance for a hearing that's the right venue to marshal proof, subpoena witnesses, and make precise legal arguments.
Just understand what the judge asked you regarding those two charges.
Did you just understand that I think there's a bigger overriding issue? Thank you.
Hang on.
Thank you.
I'm not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already.
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between you and Ms. Bridges.
I just like to, state that.
Well, I think we need to back it up.
Pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future hearing.
No, but all of my rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She was working, okay,
Okay, you're going to get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridgman.
Okay,
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she was
today's purpose is
investigating, okay.
Today's purpose is to advise you of the 2 contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying here are the charges? Because this does not match, sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay? It does not say,
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
why have they changed,
I'm
Judge
not
Becker?
answering that question.
Can the prosecutor?
No,
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those,
then I'm going to appoint
not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what
How
happened.
can I do?
Here, the judge pushes back on the not authorized claim important moment. The court is distinguishing between what an investigator or trooper told the defendant and what the court has officially ordered. That distinction matters in appellate review later. Testimony, clerk's notes, and filings on the docket beat hearsay or field reports. If you're building a defense around what a trooper said on the phone, you need that person on the record or a written statement. Otherwise, it's the defendant's word versus the court's file. Save the rhetoric for the hearing, use sworn statements and exhibits.
I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand that?
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gaffier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
Now,
common
it's
law
not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty.
Correct.
That's correct. Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again.
Major tactical point. The defendant asked for a jury trial. The judge correctly denied it because contempt usually lacks a jury right. That's a key procedural reality that people miss in viral clips. When someone waives a jury trial demand like a magic trump card, It rarely changes the legal landscape for contempt matters. Instead, focus on admissible evidence and witnesses. The judge's timeline and the scheduling of a hearing gives a structured opportunity. This is where you place exhibits, testimony, and challenge alleged facts. If you're serious about defending, spend energy on discovery, subpoenas, and case law, not on courtroom monologues.
See where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What one do you have?
And this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items checkmarked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than now.
I'm going to find that.
Please, Judge Gothier.
Sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing Defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you generally like to see what she has here?
I just,
okay. So how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing.
But I wasn't on bond. So both show causes are not in effect because I'm...
Date of the first show cause?
December 20th.
No, December.
Oh, sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today we're going to schedule a hearing date and you can present that evidence at that time.
And how will the hearing affect a trial by jury?
As I told you, there is no right to trial by jury
for a contempt charge.
So
so this is a perfect, nice little tidy package for everything.
Scheduling the contempt hearing is a practical win for both sides. It forces proof and limits theatrics to a bounded event. The judge offering a later date recognizes the defendant's need for time to gather witnesses, but it also prevents indefinite delay. Pay attention to the subpoena path explained by the court. Self-represented litigants can compel witnesses, but only with the court's signature. That's a tactical nuance. You can't just demand witnesses show up, you must follow the clerk's process. If you intend to defend, use that process early. Draft subpoenas, collate sworn statements, and get the court to sign them.
Schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then. That gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long as I'm convinced that you're doing so of your own free choice, that you understand what's going on, and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own. So if you want to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to.
Ms. Richmond,
okay, I get it, Judge Gauthier. I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common?
Here, the court confirms the right to self-represent if the choice is knowing and voluntary. Big caution: self-representation in a criminal contempt setting raises risks. You'll be expected to apply case law and meet evidentiary rules. The judge warns this directly. An attorney has research tools and training. If you choose to go it alone, your preparation window is now not the morning of the hearing. Gather statutes, Michigan Supreme Court opinions on unauthorized practice, and any proof about who was or wasn't allowed to meet with counsel. This is the moment to pick a strategy. Plead, negotiate, or litigate with precision.
There are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the codes and statutes.
Is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training in researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see.
When the judge says the prosecutor must prove beyond a reasonable doubt that you practiced law, that's the battleground. Unauthorized practice cases turn on definitions: what exactly the person did, whether they held themselves out as counsel, and whether they performed legal services. The Michigan Supreme Court has precedent defining relevant elements. The defendant will need to attack elements, identify gaps in proof, and show reasonable doubt. If evidence is thin, no witness saw legal advice being given, no documents supporting practice, the defense can win. That's why detailed witness lists and exhibits matter.
If you want to hire an attorney, or if you want an appointed attorney, they would they would be able to fashion those arguments on your behalf. But I'm not gonna,
No, I've been
Tell
down
me
that
what
path
those
before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
it's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yep, Ms. Richmond, if you want to represent yourself, it's a little bit more work. You're gonna have to-
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with, or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank
legal
you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I
Right.
would review. It'd be the district court office
Okay.
that I would review, and I would issue the subpoena. If it's-
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of
get it,
charges to
but
set-
I appreciate that this is very big in scope, and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know.
Subpoena mechanics again. The court reminded how subpoenas get issued through clerk review. Small procedural steps like this are often where self-represented litigants stumble. File the subpoena forms early, propose the witness list to the clerk, and be ready to show relevancy. Also, documentary evidence, emails, call logs, or the original show cause form photo the defendant mentions can be compelling if authenticated. The defendant claiming she has photos on her phone but not on the record is a missed chance. Get documents into evidence through sworn statements or authenticated exhibits.
Thank you, I appreciate
And Ms.
any
Richmond,
clarification.
I do have to follow what the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
She's not going to come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I've given you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights. Of course.
And most of what I talk about actually falls under common law because it's common that anyone could understand it.
Now, bond. The judge is weighing release versus secure bond because of risk of non-appearance. Bond amounts are a mix of community ties, risk, and the court's desire to ensure attendance. The judge cited prior conduct tearing up a show cause notice and failing to appear as behavioral evidence. That's often decisive. If you think bond is excessive, prepare a written motion with proof of ties to the community, health conditions, and willingness to comply. But again, rhetoric about oath to defend the Constitution won't change a bond decision unless supported by concrete evidence that you will appear.
All right.
That's why it's called common.
Set the hearing date.
Okay.
We'll bring you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps that's the overarching question here, I think. And I think a lot of people
Well, I can
struggle with
recommend a
that.
Schoolhouse Rock video to you about how a bill becomes law, and the laws.
Oh, I know how it happens.
Your Honor,
I also know we don't have a lot of judicial review.
So
Your Honor,
that's the
pardon
bond
me.
question. Any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf, would you like to-
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed.
Judge sets bond at $10,000 cash. That's significant. The court balanced community safety and flight risk with the defendant's history. This is one of those moments where the consequences of earlier choices crystallize. Missed hearings and deliberate refusal to comply lead to higher financial stakes. If the defendant wants to attack this later, show evidence that you'll appear housing, family responsibilities, medical needs. But the practical takeaway for viewers: don't treat court dates like optional events. Ignoring them escalates exposure quickly.
To this area, this local municipality, it seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It wasn't
didn't.
an offer, it was an order
Sorry.
to appear.
They didn't actually hand it to
People
me.
just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety to the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to do it today, Mr. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's right. All right, we'll adjourn.
That's right.
I know. She's only up here from North Carolina.
Final recap. This is a classic docket-level collision between procedural authority and a performer's protest. The court has alleged 2 contempt counts: unauthorized practice of law and preventing a defendant from meeting counsel, both serious. The judge ensured the defendant understands rights and penalties, scheduled a full hearing, and set bond because of prior non-appearance. What matters going forward? 1. The prosecutor must prove each element beyond a reasonable doubt. 2. The defendant must produce admissible evidence and witnesses at the hearing. And 3. Procedural steps, subpoenas, authenticated exhibits, will decide the outcome more than courtroom spectacle. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.